call this meeting to order. Could I have a roll call, please?
Derek Alves.
Karen Keith.
Daryl Jern.
Here.
Okay, we have a quorum here, so we'll continue on with the meeting tonight. Did everybody receive the packet that was presented or provided to us tonight, or prior to this meeting?
Yes, sir.
Has everybody had an opportunity to review the previous minutes?
Yes, sir.
Is there any comments or issues with the minutes as written?
No.
Do I perhaps have an approval of a motion to approve the minutes as written?
So moved.
It's been moved and seconded to approve the minutes as written. All those in favor signify by saying aye.
Aye.
All those opposed? Motion passes. Next on the agenda, communications. I don't believe we have any communications, do we?
There are no communications, Mr. Chairman. That was me.
Oh, okay.
Oz.
Next on the agenda, unfinished business. I don't believe we have any unfinished business. Next on the agenda is a hearing of appeals. Case number 11-110-1. With that being said, I believe at this time
I'll introduce the
Okay.
item for you. Mr. Chairman, board members, my name is Joe Schmitz. I'm planning manager for the city of Goodyear. And what I'd like to do is just introduce the case to you. This is case number 11-110-01, which is an appeal of the decision by the zoning administrator to deny an application for zoning clearance for an assisted living home with up to 10 clients at 4434 North 153rd Lane. All of the notice requirements have been complied with by publication of notice in the newspaper and posting of the property as required by the zoning ordinance and state law. The applicant is Successful Journeys, represented by Dustin Jones of Livability Law. The location of the property involved in the appeal is generally at the southwest corner of 153rd Lane and Roma Avenue in Goodyear in Palm Valley, and more specifically described as Lot 2 of Palm Valley Phase 5, Parcel 7. The nature of the request is an appeal from the decision of the zoning administrator to deny an application for zoning clearance for an assisted living home with up to 10 clients at 4434 North 153rd Lane based on failing to meet the 1,320-foot separation requirement from another assisted living home with up to 10 clients for which a zoning clearance had already been issued. There have been no communications received that have been directed to the board on this matter other than what you received in your agenda packet. In the agenda packet for the item, you'll find a copy of the staff report for this matter, together with a copy of the appeal filed by Mr. Jones on behalf of Successful Journeys, including Exhibits A through G, and an additional 19 exhibits labeled 2 through 20 that have been provided in support of the staff report. It is the recommendation of staff for the reasons contained within the staff report that the board uphold the May 11th, 2011 decision denying the Successful Journey application. With the item now having been introduced to the board, I would like to just briefly describe the proceedings as they are intended to go forward. The planned order of the hearing calls for Mr. Jones to present the applicant's case and all evidence supporting the appeal. The chair may then inquire if there are others affected who support the appeal who wish to speak. The chair will then call on those opposed to the granting of the appeal to present their arguments. The city's position will be presented by Assistant City Attorney Sarah Chilton. The chair may then inquire if there is others affected who oppose the appeal who wish to speak. The applicant shall then have the right of rebuttal to arguments presented by the opposition. And I believe the board has the ability to ask questions throughout the process. And I would ask you if you had any further questions, procedural or otherwise, to direct them to the attorney, Ellen Van Riper, who is representing the board this evening. Thank you.
Okay, first on the agenda for giving your case of the applicants.
Mr. Chairman, members of the board, my name is Dustin Jones, here on behalf of my client, Successful Journeys, who is the applicant for this appeal of the zoning administrator's decision denying their application to expand their assisted living home from 6 to 10 residents. Before I begin, I'd like to have them, my clients, approach and introduce themselves so you're aware of the type of services that they provide and the type of assisted living facility that they have in current operation. And the Jacksons would come forward.
Hi, Chairman and members of the board. My name is Wendy Jackson. Okay. Good evening. My name is Wendy Jackson. I'm the president and co-founder of Successful Journeys, LLC. I am the Human Resources Director at a local city and been residing in Arizona for a little while. And I have a master's in labor relations, and my undergraduates is in human services, and this is something that we take pride in. We try to provide some quality services for people who are in need. I'm going to let my husband go into a little bit more about what we do.
Good evening, members of the Board of Adjustments. My name is Sekou Jackson. I'm the clinical director, also the chief operating officer of Successful Journeys. I've been in this field for about 14 years. Have an undergraduate degree in human services, has a master's degree in public administration. I'm also a certified public manager here in the state of Arizona. I worked for the state for about 6 years as an administrative service officer for the Department of Economic Security. I was overseeing their program evaluation and monitoring unit for the Employment Administration. I did that for about 3 years. I left the state in January of this year to go full-time with Successful Journeys. We're a small human service agency. Our primary clients are what we consider a geriatric type of population. However, we're licensed for adults, which means 18 and over. We take clients who have barriers to living independently. We're a level 3, what you consider a level 3 behavioral health facility. That simply means that these clients are one step away from independent living. So the types of services that we provide in the house is independent living skills. We do their money management with them. We do social and recreational type of activities. The whole goal is for them to hopefully be able to live independently. Now, because they have mental health issues, that may not be the case. Some of them may succeed, some of them may not. We're considered long-term care. This business of Successful Journeys was actually something that we've always wanted to do. I met my wife in undergraduate studies in human services, and she eventually transitioned into going to human resources, but I stayed within doing direct care. Then when I got my degree, I actually transitioned into a managerial type of position. When I got my master's, I transitioned and got my first directorship in Connecticut. I was a director of health and aging for the Capital Region Conference of Churches, which is a 100-year-old ecumenical organization. I did that for about 1.5 years, and then we relocated here to Arizona, which we love this state. Don't think about moving back, but we love this state. When we came here, we bought a home. We actually bought 2 homes. We lived in one, then we thought we could sell it. And we moved into another one, and we got caught in the mix with the economy. We didn't know it was going to happen that way. But both my wife and I were God-fearing, and we knew that God would lead us in the right direction. And I had a dream one night, and typically I don't remember my dreams, so I knew that I needed to tell someone. So I woke my wife up and said, "Hey, I just had a dream that we had clients." And she said, "That sounds good." Now, normally my wife, she doesn't agree with me on certain things. And this time, she said, "I think we can do this." And that led us into seeking out, doing our due diligence, finding out how we could operate our own facility. I've done that before, but I've always done it for someone else. And now I have an opportunity to do it for myself. And again, I left a secure job. I was over the workforce development programs, monitoring contracts, jobs program, SNAE&T, which was formerly known as food stamps. So, in this day and economy, I had job security. So I left the state, and I'm doing this full time, and this is my livelihood. I have two sons. I have a 3-year-old and a 6-year-old. They both go to school in Goodyear. Most of our employees live in Goodyear, and we give back to the community. Thank you.
I want the Jacksons to have the opportunity to speak. This is a matter that's very near and dear to their heart, the operation of their facility. And they've been looking to expand. They've had success in what they do. As you hear Sekiu talk about the business, he didn't get into any details of the individuals, but in talking to him, he feels very passionate about the opportunities that they provide, primary geriatric types of patients or clients, but they do good service and they do good work in the community. They have been working with the city for a little while to realize this dream. I wanted to talk initially about just the general standard of what we're asking you to do. It's not often that I'm before a Board of Adjustments and asking for an appeal of a decision of staff on something that they've done. It doesn't happen very often, although I hear these types of cases on my own. Like yourselves, you've given up time this evening to come to this meeting and hear these cases as members of the Board of Adjustment. I sit on the Board of Adjustments as well, but I sit on the Board of Adjustments for Maricopa County. So we hear all of the county same types of cases where someone's appealing staff's decision or they're asking for a variance, and I've done that for about 6 years. And it's often a precarious situation because you're in a situation where you're overlooking staff's judgment and decision of what they did and why they did it, and who am I? I don't do this every day, but as a member of the Board of Adjustments, you all get to kind of, as fresh set of eyes, look at the situation, look at the facts as to what happened, and make a decision within your discretion to, as the statute reads, and if I could submit just a copy of the state statute for us to review. I'll give council or the city a copy there. And this is just the Arizona provides statutes on boards of adjustments, and it talks about you all being able to hear and decide appeals where there has been an alleged error in the staff's decision regarding a requirement, something that's in the zoning ordinance, something that's been applied to an individual. You might be able to reverse or affirm, wholly or in part or modify the decision made by staff. In this case here, our official application, which was submitted on April 1st, was denied a month or so later. But that's not the entirety of the story, and that's what we really wanted to speak to today, was the context of everything that actually happened that led up to that April 1st denial of our application. If you have in your staff packet on page 2, I want to speak to the legal standard of the city for reviewing these types of applications. On page 2 of your staff report, I believe it's just a quote right out of the ordinance that talks about assisted living homes, at the very bottom of the last paragraph, assisted living homes with greater than 6 residents, closer than 1,320 feet, which is a quarter mile, from an existing assisted living home with 6 or more residents, is subject to going through the city council process and getting a use permit. So if you want more than 6, and you come to the city, and as the ordinance reads, there's an existing assisted living facility, and you want the same amount that they already have, then you need to go through the use permit process. The operative term here that I want you to focus on is existing. Existing is, in my mind, is one that has been approved by the city. It's in operation. It actually does exist. The other part of this standard is if you look up just above that where it says assisted living home, talks about an application for an assisted living home must be submitted, reviewed, and approved by the community development director or his designee prior to a zoning clearance. So what we were applying for, anyone that wants one of these, they're applying for a zoning clearance. And there's a process of submitting it, reviewing it, and approving that. I submit that once you've submitted, staff has reviewed it, and they've approved it, then you exist. Anything prior to that is a mere application that's been submitted that may not meet all the standards. That's why there's a review process. It must be reviewed, and then you must make sure that it is complete. It's a complete application. And once that determination has happened, then you approve it, and then you actually exist. That's the three-step process: submit, review, and approve, and then you exist. And because we believe that staff made a mistake in its decision-making with respect to my client when they approached the city and attempted to apply for one of these applications for a zoning clearance, the city did not meet this standard, did not meet their standard. You all, as the Board of Adjustment, can look at these facts, look at this situation, and determine whether, based on the information in the record that we provide to you, that you can reverse that decision and acknowledge that maybe there was a mistake in not following these steps and grant the zoning clearance, or reverse the denial of the application for the zoning clearance. So let me go through just some of the facts here that lead up to this scenario that the Jacksons and Successful Journey are in. Back in 2008, when they were looking to open the first facility, they came to the city, and they asked if they could submit one of these applications again to do the submit, review, and be approved. And at the time, back in 2008, there were 2 existing applications at the city for zoning clearances under the city standards. They already existed. Zoning clearance letters had already gone out. The first one was in 2006. It was the Paisley property, and then there's the Latusic property. And because those 2 properties were in existence and they had been approved for zoning clearances for residents over six residents, the Jacksons, Successful Journey, were not allowed to submit their application. It's just the strict application of the rule. So this was the first strike, and we have no question, and that's not the issue before us. But just to give you the history, the Jacksons came in, submitted their application, or talked to staff about it. Staff looked at their system. There's 2 in existence already. If you want to have a assisted living facility, you're going to have to go the use permit process. It's not going to be one that we can approve over the counter. So that's the first time. And that was 2008. So 2 years later, in 2010, so the summer of 2010, and if I could have another communication I'd like to have submitted. This is Katie's. I'll give you a copy. Up to you as well? Okay. If you can. And I'll wait for you all to get that.
To label it, exhibits, numbers, or just?
Shane, you're going to get them to them. Then you can.
Thank you.
Shane, I think I gave you my copy. So this is an email that Mr. Jackson sent on July 12th. July 12th, just last summer, to Katie Wilkin, one of the staff administrators, one of the planners. And in his email to her on the 12th, he says, I need to know prior to securing this property, he's looking, if our behavioral health facility is an allowable use zoning for this location. If so, is the maximum of 10 persons still an option? Please respond. So he's just inquiring, can I get 10 residents on this house that he's looking for? He sends this email on the 10th. He never got a response from this email, and this was not submitted to you as an exhibit. And I don't know but we received it after doing a public records request, that he asked on the 12th to find out whether he could have opened this facility. He never got a response back. 2 days later, as the staff report indicates, staff sent out letters to the Paisley property and the Latusic property because they had existing zoning clearances for their assisted living facilities on the record that they had obtained back in 2006 and 2007, but they were in operation. And as you can imagine, what was going on, as Mr. Jackson has indicated, back in the day, many people were investors and were looking for properties and would tie up a home, submit a zoning clearance application for their potential assisted living facility, and then the house goes into foreclosure or something like that, and it never comes into fruition. They don't ever open up the assisted living facility. But what was happening was these letters, these zoning clearance letters for assisted living facilities were still on the records of the city. And as a result, when Mr. Jackson inquired, he never got a response back at the time, but the city recognized that there were these zombie zoning clearance letters, for lack of a better term, sitting on the city's records. They were essentially would have precluded Mr. Jackson from expanding because they were sitting there. If you could turn now with me to the city's Katie Wilkins declaration, which I believe is Exhibit 12?
18.
Is it 18? I think it's 12.
Oh, that's
Exhibit 12, right? Yes, Exhibit 12. This is Katie Wilkins' declaration. I'm going to read quite a bit of this and just kind of talk about the facts, because she goes through, and her story is essentially our story. It's just from the city's perspective. But many of the points that she outlines in her declaration we concur with. So at sentence or paragraph number 4, she says, prior to July 10th, the city issued open-ended zoning clearance letters for assisted living home applications seeking approval for more than 6, which I've just talked about, these letters. In mid-July 2010, I was tasked with providing information the city was asked to provide in connection with the census. Specifically, I was tasked with verifying the number of these assisted living facilities within the city. She says that she started doing this mid-July of 2010. The email I just submitted prior to you is our inquiry to her July 12th, also mid-July. So according to Katie's testimony, her declaration, she's in the process of reviewing how many of these assisted living facilities are in existence. We don't know if she was doing this prior to our inquiry about assisted living facilities or not. We know that these two, the Paisley and the Letusip properties, would have precluded us. She would have come back and said, no, you can't because there's 2 in existence. We don't know the timing of the events, but based on the declaration, her own testimony, she's saying that sometime in mid-July, she was already doing research on these assisted living facilities that existed in the city. Paragraph number 6 says, during this process, I discovered that certain applicants who had obtained zoning clearances for assisted living homes had not established those assisted living homes. They had gotten their clearances, but they hadn't done anything with them, which is what I was just alluding to a second ago. As a result of this discovery, I sent out letters to the applicants with outstanding zoning clearances, advising them that the zoning clearances would be terminated if they did not obtain a certificate of occupancy within 30 days. So these zombie types of letters that were out there that were essentially placeholders for assisted living facilities weren't in operation. The city sent out these letters on the 15th of July, notifying them, if you don't come in for a C of O within 30 days, we're going to revoke this clearance. 10 days later, on July 25th, so just 10 days after the first letter giving them 30 days notice, a subsequent letter went out to these 2 particular properties advising them that their zoning clearances had been terminated, that they had gone away. And so therefore, there were these 2 properties I've alluded to, essentially as of July 25th, were notified that they were no longer on the record as a city of having zoning clearances. At that very moment, again, this is within days of the Jacksons inquiring with the city through this email that I submitted to you. Within that time period, mid-July, when Katie is doing her cleaning out of all these applications, we're inquiring about the assisted living facilities. They already had one in operation. They were already operating on the one they had gotten back before this, but they were in the process of wanting to expand to 10. They were just actually trying to open up and go to 10. As a result, they were told they could not go to 10, that they had to remain at 6. And so they just pursued and went through the process. I don't want to get into the minutiae of all the different conversations that went on, but this point here, focusing on 2010, it was very clear that there was an inquiry in July 12th of 2010 asking about going to or operating a facility with 10 residents. At the same time that staff was kind of going through these files. We don't know what happened first, but we do know that at that time, when the Jacksons wanted to open up a facility with 10, they weren't notified. So essentially, these 2 properties, the Paisleys and the Letusip properties, disappeared in the summer of 2010.
I just have a quick question.
You bet.
I'm just curious as what prompted Mr. Jackson to inquire about during July of 2010 to inquire about the ability of being able to increase the size of this facility? I don't know if you can answer it or not, but I'm just curious.
2008.
I'm just going to reiterate what I thought I heard. You want to know why in July did I inquire about increasing the occupancy?
Yeah.
Why did you send that email?
Okay. I sent the email because we had separation we always wanted to do 10. Clearly, we couldn't do it at the 4434 location, but our desire was to do 10. So we were trying to find a location that would not fall within the quarter of the mile limitation.
So your inquiry was the potential of perhaps procuring another facility for 10 occupants?
For that email, correct.
Okay. That's all I want to point out. Thank you.
So the first,
Mr. Chair, I have an opportunity for
Yes.
a question. Okay. I'm going back to Katie Wilkins. You mentioned number 8, a number of zoning clearances were terminated, and I want to make sure I heard you clearly, because do you say which ones were, or just going back based on her statement there were a number of ones, and we don't know which ones?
the staff report shows that the Paisley and the Tucson were canceled at the time.
On July 25th.
Okay, I'm just going by her statement, which says, I think you read something to the statement. The statement I have says, number 8, a number of zoning clearances were terminated, and you went on to say which ones, and I'm just trying to say, why is that not in her statement?
The Latusic and the Paisley property applications were terminated. It doesn't say that here.
Okay,
But
okay.
it,
Yeah, and that's in
Yes.
your staff, that's
Okay,
in the.
all right.
and it's
Thank
in
you.
the staff report within
Okay,
the,
just make sure we're clear. I was trying to go on her
Into
statement and follow.
documents.
Thank you. Okay.
Yeah, her declaration doesn't specify these two because she was going through the process of terminating a number of them. But as it relates to us, the two that were precluding us from going to 10 were these two zombie ones that did receive letters the 25th of July, and they went away. That was an opportunity that the Jacksons could have submitted and gotten 10 at that very moment that these letters had gone out. They had already had contact with the city inquiring about going to 10. Somewhere in that 2-week process, no communication went back to the Jacksons about, yeah, we sent out these letters to these two properties that were holding you back from going to 10, and you can come in and submit. It would have just been at the counter. They would have submitted. There were no other potential properties, and we wouldn't be here today.
Okay, and my follow-up question goes to the email, and this question is for you, Mr. Jackson. Oftentimes we send an email. Can we confirm or deny that Ms. Wilkins actually received this email?
Yes, we
Okay.
can confirm because we received this from the city through a public records request. It's not in your packet, but we received it from the city. So that was the second missed opportunity to go to 10. The first one being these two properties that exist in 2008 that were preclusive, and then in 2010, the same properties were precluding, but somewhere in that time period, they went away because the letters went out from the city. The Jacksons were never notified of this. So now let's move forward a few months into 2011, and what I wanted to do is again kind of reference Katie Wilkins' declaration, and we'll just go from her timeline of events that occur here. And now, if we can move down to 13. Actually, it's already been established on the record that there was a FedZen application. The FedZen application came into the city and was approved. It was submitted on the 16th of February, so that's paragraph number 16. So there was an application that comes in for more than 6 on the 16th of February. By March 10th, paragraph 11, the city has approved Mr. FedZen's application. Mr. Jackson comes into the city on the 22nd, so just a week or so after, obviously unbeknownst to him that Mr. FedZen had submitted an application for a zoning clearance application on the 22nd, and he approaches staff wanting to go to his 10 again, and he's told, and we'll just read right from the record here, at this time, I informed Mr. Jackson that the city had recently received a zoning clearance application for a facility located within the quarter mile of Successful Journeys property, and that the city's policy was to process that application in the order of receipt. I advised Mr. Jackson that it was pointless to submit a zoning clearance application and pay a non-refundable fee in light of the pending FedZen application, but I never told Mr. Jackson he could not submit such an application. I submit to you that, again, Mr. Jackson comes to the city wanting to submit his application and go through this process, and if staff told him it was pointless to submit an application on February 22nd because there was this other application that was pending, this is the first of big mistakes I believe that the city made. The city's policy is this first in time, first in line. First in time, first in line. And we have in the record Joe Schmidt's his declaration where he talks about the first in time, first in line policy that the city has. The code, as I articulated at the very beginning of this, is to submit, review, and approve. The SRA is the steps. You must submit, be reviewed, and approved, and then you exist. At the time that Mr. Fedson had submitted his application on the 16th, the time that Mr. Jackson, my client, came in on the 22nd, he just had an application that had been submitted in the process. Submitted. It had not been reviewed, and it had not been approved. He did not exist. I submit to you for staff to tell my client that it was pointless to even apply at the time is in violation of the code. That's the mistake. Because anyone knows, just as the city saw with these other applications, just because someone has submitted an application doesn't mean that it's actually going to go into existence. They may not proceed with their application. It presents an opportunity for anyone, a potential competitor, that may want to get you out of the business. You just go down to City Hall and submit an application, and you basically have put your stake in the ground, and no other assisted living facility can come in anywhere near you. So on February 22nd, as Katie's declaration states, where she told him it was pointless to submit a zoning clearance application, that's a mistake. That's not correct. It wasn't consistent with the code. Although it was the city's policy to the first in time, first in line, even first in time, first in line, to me suggests first in time means you exist. You've been approved. And that's the process. You get yours. It's not in the order of who gets down to City Hall and submits an application and stakes their stake around because you haven't gone through and you haven't been approved. Following along the declaration, at 15, again, she says, I did not refuse to allow Mr. Jackson to submit an application. She did not refuse to allow him to submit the application on February 22nd. I was a teenager. I was in college, and I did try to pick up on girls. And I pick up on a girl, you go and you talk to somebody, and if she tells you, and you're sitting at the bar, it's pointless for you to call me, I think that's a pretty big hint. You don't pursue that. If I talk to her a month later or 2 months later and she says, why didn't you call me? I never told you not to call me. I would scratch my head and say, you told me it was pointless. In this instance, when my applicant approaches the city and the staff tells them it's pointless to submit an application, you may not be telling them do not apply or you can't apply, but you've given them a very strong indication it's pointless to apply. Again, you submit, you review, and approve before you exist as a assisted living facility in the city under the city's code. So the policy as applied here of first in time, first in line, was not applied appropriately, and I believe that the code, the city's actual code for this, was not followed exactly as well.
If I may interrupt you for a
Yes,
second.
you bet.
Mr. Jackson, so he came in early this year to inquire again about an assisted increasing or pursuing a facility with 10 residents.
Correct.
Was that a follow-up from last year, or was it was it knowing that what was he asking for?
Mr. Chairman, from 2008, summer 2008, summer of 2010, it has always been the Jacksons' intentions to go to 10. When they came in 2008, these two properties existed, so that was not an opportunity. When he came back in 2010, summer, he sent the email, the one that you've spoken about. It was still indicating to the city, I want to go to 10, but these two
I believe the
properties.
inquiry in 2010 was inquiring about perhaps procuring another facility where they could have 10 residents.
But the property in question has always been the same area. He was looking for homes along this street in this area. He was trying to figure out the distances within this area, within the area we're speaking of.
So if I'm not mistaken, he was looking for the potential of purchasing another facility for that purpose.
And I believe he said that when he that was asked of him before.
This meeting in February is the property he's in, correct?
Okay.
Yeah, but what I'm trying to lead up to is, I was going to ask another question was, so he came back in February 2011 seeking the potential for another application, correct?
No, just to increase my current facility, to increase the numbers.
Oh, okay,
Which-
all right. So it's for the existing facility.
For the existing facility, which, according to what happened, it required separation.
So what prompted you to make that inquiry in February of this year?
Tax returns, we had some money, we can do some retrofitting. We always wanted to increase to 10. We thought it was a perfect opportunity because we had the finances to do it.
You said retrofitting, you have to make modifications to the home if you have a certain number of residents for the city's building.
But at that time, did you know you could do that? I guess, did you know that back in 2010, that the two existing conflicting facilities had their licenses revoked?
We didn't know that their license were revoked. We just found that out through discovery when we had to hire a lawyer.
They were just told they couldn't pursue that, but there was never indication to them that there are two properties. What was the basis for the cities, even at that time in 2008, 2010, telling them they couldn't do it? But one can easily conclude if they came in 2008, these other ones were in existence in 2006 and 2007. They were within the quarter mile. They couldn't. They knew they would have to go to a city council and get a use permit back in 2008. And then again in 2010, last summer, the city never responded, is essentially what happened last year. This email that I submitted to you, he never got anything back from Katie. But again, it was the 12th when he submitted the email, sometime in July, based on her own declaration. She's doing the research. One could surmise that the city could have called him. I mean, she sent out the letters and got rid of these two. They could have called him, and then he could have gone to 10, and it would not have been an issue. It's just kind of part of the facts of the story that has been going on with them trying to expand and go to the 10.
Mr. Chair, if I may, the current property that you have, what is that location, the address?
4434. It's the one that's noted in
Okay,
the
yeah,
declaration.
I'm trying to get to the subject line in the email here from Mr. Jackson. The subject is 16645 Santa Maria Drive, Goodyear. Is that your home address, or what? That's the subject of the email. I'm trying to put two and two together here.
If you're going to go based just on the emails, a lot of conversations are verbal, which we know now that whenever we have a conversation with someone from the city, we need to follow up with an email. So you're not going to see, verbal conversations.
No.
Right? So that address is a different property because we have separation issues at 4434. We were trying to find a property that would not fall within the quarter of a mile radius. So that property, I don't know if it fell in a quarter of a mile. I never received a response.
Well, I'm saying, but from
Right.
trying to understand the property locations, and I
Right.
see the subject here. I'm not trying to put myself in a case position, but I'm trying to. What is the correlation between your current existing facility and the subject line here in terms of 16645 Santa Maria Drive? That's the subject of the email. I'm trying to get
Right.
understanding.
So that is that's another property.
That you were looking at.
That we were looking at, that we was hoping it was outside of the quarter mile radius.
Okay.
Thank you.
Because the other two were precluding them, so
Yeah,
that's
okay, I understand.
a desire to move. Okay, continuing on, just referencing Katie Wilkins' affidavit or declaration. 16, after Mr. Fedzin's zoning clearance application had been approved, a meeting was scheduled with Mr. Jackson to discuss what would be needed if he wanted to pursue the use permit that would allow him to go higher. That meeting took place on March 31st of this year. In paragraph 17, Mr. Jackson told me that he did not want to pay the $1,500 non-refundable fee to apply for a use permit at that date, and so no use permit was filed at that time. Around the same time, he informed me by email that Mr. Fedzin's application was a fraudulent application because he did not own the property in question. Mr. Jackson submitted a zoning clearance application seeking to increase the number of residents at Successful Journey. In your packet, exhibits number 17 and 18 are email correspondence if you go to 18, 17 is the initial email from Mr. Jackson to Katie. 18 is the thread, so you get both of them in 18. But essentially, Mr. Jackson is inquiring about the separation issues. He's found out that Mr. Fedzen that there was a Fedzen application zoning clearance that's been approved. Again, that application from the city was approved and issued to Mr. Fedzen on March 10th. So now, this is now this email. If you look at the date on this email is from Mr. Jackson to the city is March 31st. So just 21 days after the Fedzen zoning clearance is approved, and Mr. Jackson's being told that there's this other property in existence that has 10. Sorry, you can't go. It's now 2 times now that he's been trying to get to 10, and this property comes in and gets approved. They send it out to Mr. Fedzen on March 10th, and Mr. Jackson's inquiring about this on the 31st, and then I believe Katie gets back to him on April 1st. According to her testimony, again, going on number 19, although Mr. Fedzen's application had already been approved by the time Mr. Jackson informed me of this purported fraud, I did follow up with Mr. Fedzen. So Mr. Jackson sends the email to Katie saying, what's the address of that property that's been approved that's holding me back? She sends in the address. Mr. Jackson does some due diligence, and based on his online research and correspondence, he finds out that Mr. Fedzen doesn't own the house. She's like, how can you guys have issued a letter on March 10th approving a zoning clearance for Mr. Fedzen when Mr. Fedzen doesn't own the property? And Katie's statement tells us at that time, she was almost as though this was the first time she'd heard of this, she says she then followed up with Mr. Fedzen. This is now April 1st. According to the emails that you have in your packet under exhibit number 19. He informs them, this is exhibit 19, Mr. Jackson informs Katie that about the fraud. This guy does not even own this property. Why did you guys give him a zoning clearance for him to proceed? Exhibit number 20, so going from 19 to 20, exhibit number 20 is the special warranty deed where Mr. Fedzen actually takes ownership of the property. It was recorded April 1st. Interestingly, the same day that Mr. Jackson calls the city, calls Katie and says, wait a minute, that person doesn't even own the home, April 1st, or April 31st, and Katie then, in her own statement, says she follows up with Mr. Fedzen. Mr. Fedzen informed me that he was in the process of closing on the house. This is, I'm again reading from paragraph 19 of her declaration. He was in the process of closing on the house when he filed the zoning application on February 16th. He subsequently provided a copy of the warranty deed that showed the property had been conveyed shortly thereafter. Shortly thereafter wasn't too short after. He submitted the application on the 16th. In your packet, the application that Mr. Fedzen submitted is exhibit number 13. And on the application, exhibit number 13, exhibit number 13, this is the application that Mr. Fedzen submitted on the 16th of February, acknowledged, signature of the property owner, and Mr. Fedzen signs it, February 15th, 2011. This is where my client says, City, this is a government document. Mr. Fedzen submits an application to you. He does not own the home. He's not the property owner. And he submitted this to you. And then you all a month later, less than a month later, give him an approval. As Katie's declaration clearly indicates, they didn't know he didn't own the property. They didn't even know. It was only discovered through Mr. Jackson emailing and saying, what's the address of this person that's procuring me? He goes and does some research, finds out this guy doesn't even own the home. They do some research. Katie calls that property owner, Mr. Fedzen, and says, probably says something to the effect that we got someone calling saying you don't own the home. The records indicate you don't own the home. Mr. Fedzen then provides them with a copy, or probably runs down that same day because all this is happening that same day. And he goes and records it. In your packet, again, exhibit number 20 shows it was recorded on the 1st of April. And also, if you look in that top right-hand corner, it also indicates very clearly when the city got it. It's stated right there. Mr. Fedzen, top right-hand corner. It's written in handwriting. Mr. Fedzen submitted April 4th, 2011. So at April 4th, 2011 is when finally the city has found out that the guy owns the property. The city issued a zoning clearance for him to expand on March 10th. All the while, had not done any reviewing of the application to determine that the applicant who submitted the application actually owned the property. So, again, on April 1st, Mr. Jackson recognizing that he hadn't submitted an official application, so there would be an official denial, submitted an application for this for approval on April 1st. That is the date that the city's staff report is indicating as the day that my client applied for this zoning clearance and then was denied in May afterwards. Again, the technical process is, yes, he applied on April 1st and was denied in May. Yes, when it was received on April 1st, Mr. Fedson's application had already been approved. His zoning clearance had already been approved on March 10th. But if you look at the chronology of events, the city received Fedson's application 16th, approved him on the 10th. Mr. Jackson came in on the 22nd, was told it's pointless for you even to apply because we just received this other guy's a week ago. The city approves Mr. Fedson. Jackson is notified that Fedson has been approved on March 31st. He sends the email. It's in the record. April 1st, he goes by and tells the city, this person doesn't even own this property. Katie's declaration says she calls Mr. Fedson and says, do you even own the property? Mr. Fedson then provides her, or probably runs down, based on the chronology, runs down and gets it recorded on April 1st, that same day as the date says, and then submits a copy on April 4th to the city to prove, I do own the property. Again, this process indicates that there was a misapplication of the standard, which is submit, review, and be approved. And once you exist, you can have an actual, you can actually have your license, your zoning clearance letter. The Jacksons have attempted, again, over a period of time to go through this process since 2008 to get to 10. They come back again in the summer, they're inquiring, trying to get to 10. And then they come in February, a week after Mr. Fedson, who falsifies the document, says he owns it when he doesn't own it. He doesn't even have an authorization from the owner, whether it was a bank or whoever it was. We don't know. But the facts that are relevant for this case is he didn't own the property at the time. The city's application that he signed says he owns it. The city issued a zoning clearance letter to him. He didn't own it. And the city didn't inquire until we advised them or informed them that this other property they don't even own it, that he runs down, probably gets it recorded, and then the city provides us with a copy on April 4th. We wouldn't be here, again, had the city followed its process on the Fedson application. We're not here to challenge that application. We're not here to challenge that application. We're challenging the denial of our application and the denial of the process, of submitting, having it reviewed, and having it applied. On February 22nd, when we came and approached the city to go to 10, the statement in Katie's declaration that it's pointless to apply was essentially a denial at that point. Don't even apply. It's pointless. It's in her declaration. He didn't even apply. And then when he finds out that some other guy cuts in front of him and gets his approved and he didn't even own the property, again, what we're asking this board to do is look at the totality of the facts and the process. And you have the ability in your discretion under the state statute to modify and reverse that denial of our application and to allow us to have that zoning clearance, which would allow us to go to 10 under the city's ordinance. The separation is, I believe, about 290 feet between our property and the Fedson. Literally about 4 houses. So if there were over 4 houses, again, we wouldn't be here because they're that close. So the discretion we're asking you to exercise in granting, allowing us to have the opportunity to receive a zoning clearance and go up to 10. Again, there are rules because the city likes to have these separated, not have too many of these types of group or assisted living facilities. They'd like the half mile. We are within 290 feet of that, which is, and when we just kind of looking at the aerials, it's about 4 houses, maybe across the street and a block or so away, but about 4 houses or so away is the difference. So if we were in that distance, we wouldn't be in this situation either. And we believe that we have gone through the process again. 3 strikes are out. Essentially, was the way we were treated. But we believe that through your review of the totality of the facts and the sequence of events, that you can exercise your discretion here and reverse staff's administrative denial.
I have a quick question here.
You bet.
So if I understand you correctly, the Fedson facility is approximately like 1,100 feet from the facility in question?
Correct.
Okay.
It's 1,100 feet away. If it was 1321, we wouldn't be in this scenario. So we're asking you to to look at staff's decision denying it and exercise your discretion to reverse that and allow us to have the zoning clearance. If you chose to do that, obviously you're exercising your discretion. You don't want to create a situation that's harmful for the community. That 4 houses, 290 feet or so, is not a huge difference than the standard that the city has. You'd be going to 1,100 or so instead of the 1,320 feet.
So I have one more question
You bet. For Mr. Jackson?
for Mr. Jackson.
Perfect.
Forgive me for asking this again. I think I understood it, but I have to ask again.
Okay.
So in February of this year, you inquired about the ability to increase your facility size from 6 to 10.
Correct.
And at that time, you had no knowledge that the other 2 facilities had lost their zoning requirements.
I had no knowledge.
So when you made that request, the only thing that you knew at that time that you were still barred from increasing the size of the facility from the city without getting some sort of
Right.
special.
Right. I was looking for the city to
Yes.
inform me if I could or not.
So I'm just wondering, so you mentioned you had some excess funds that you were willing to invest in the facility to remodel it, upgrade it for expansion, correct?
Correct.
Okay, I thought I understood that, but I just wanted to clarify that. Thank you.
Thank you.
Mr. Chairman, I believe that staff will present next. If we'd like to be able to reserve some time afterwards to rebut if we have any.
Does any of the members have questions of the, yes? Does anybody have any questions to ask the applicant? Okay, at that time, we'll allow the city to present their case.
Chairman, members of the board, before I get started, I would like to just take care of one formality. I would like to formally introduce into evidence the staff report and exhibits 1 through 20 that are referred to there, as well as the supplemental declaration of George Schmitz.
Thank you.
Thank you.
Before I begin, I think there's a lot of agreement on the record. Mr. Fedson's property is located within 1,320 feet of Mr. Jackson's existing facility. The zoning ordinance requires a use permit if there's not more than 1,320 feet separation between an existing facility and one with more than 6 residents. So I can't see without these, I guess. Although the board certainly has the power to modify an order, reverse a requirement, or a decision, it's based on an error in the order, requirement, or decision. And in this case, the city staff denied Mr. Jackson's application, or Successful Journeys application, to increase the number of residents from his facility from 6 to 10, because the city had already approved Mr. Fedson's application for 10 residents. And as Mr. Jones said, once that application approved and was reviewed and existed, it was a final decision. It existed for purposes of Mr. Jackson's application. Mr. Jackson's application was submitted April 1st. There's some suggestion that he was prohibited in some way from submitting an application earlier on February 22nd. He has never been prohibited from submitting an application at any time. there's a non-refundable fee applied. So if staff is aware of a zoning clearance that would prevent an application from being granted, they're not going to stand by and accept an application knowing it's likely to be denied because there's a pending application. And that's what Katie informed Mr. Jackson. It wasn't don't submit it, but it was why would you want to? It's a non-refundable fee. Perhaps we should change that in the future and not respond to these issues till we get an application on file so we don't have these issues in the future. And certainly after this, that would be my recommendation. The only way for there to have been an error in this case is if there had been an error in granting Mr. Fedson's application. That was granted March 10th. The time for appealing that decision has long passed. That would have expired 30 days after that, and I think that puts it at April 9th. This would be an untimely appeal to consider, to attack this fast decision and reverse the denial of Mr. Jackson's application. Not only is basically the applicant collaterally stopped from attacking the granting of the approval to Mr. Fedson, but their whole premise is that had we submitted an application on February 22nd when we came in, that would have been processed before Mr. Fedson's. And that's simply wrong. We process first in time, first in line, and we will process to completion an application received prior to somebody else's application who would be affected by the first application. So this notion that, oh, well, would it taken you longer to process Mr. Jackson's application than Mr. Fedson's application, or you would have processed Mr. Fedson's application longer, we can't get into that, and that's why it's first in time, first in line, first in time. This whole concept of a fraud, and this is the supplemental affidavit that I submitted for Joe Schmitz. We often in the city receive applications from people who are in the process of buying property and they're pending the outcome of zoning approval. Now, I suppose Mr. Fedson could in fact have said, I'm in the process of completing my acquisition. I saw a contract where he provided earnest money in January for this process. I guess that would have been technically more correct. But he did complete the purchase of the property. We would have accepted it even if he would have said that. At that time, we would have said, give us a copy of the purchase contract or some kind of owner authorization to show that you have a proprietary interest in this property. If he had been technically correct and say, I'm in the process of purchasing it. By the time we discovered it, the property had already been conveyed. Now, there's been a lot said about the recording of this on April 1st, and it was just a rush job to get it recorded after this fraud was disclosed to the city. But, and that the applicant hurried up and recorded it. But if you look at the top of that special warranty deed, it was recorded at the request of Chicago Title, the company that handled that transaction. Moreover, state law states that you have a conveyance is effective when you have a fully executed special warranty deed. Recording doesn't determine when a property conveys. This property was conveyed in February 28th, after the grantor had executed it on February 25th, and after it had been acknowledged on February 28th. And I've cited the state law provision in there.
Sarah, if I may, I think going back to that exhibit, the notarized information on the bottom is dated February 28th? Mm-hmm. Okay, I just wanted to verify that.
So, although the grantor signed it on the 25th, until it was acknowledged, it has to both be signed by the grantor and acknowledged. So the conveyance, the property conveyed February 28th, because that was the later issue dates. And as Joe Schmitz stated in his affidavit, had we known that and it had been technically correct, we would have accepted it. We would have continued to process it before we processed Mr. Jackson's application, even if it had been received on February 22nd. So there's no harm, no foul. I do want to get back to this whole notion that the city has been somewhat abusive to the Jacksons. That has never been their intent. They have met with them on numerous occasions. to discuss things, to minimize the cost for them. And we do have processes that, cost money, that, if you trigger the process, you have to start paying fees. They've tried to accommodate them to avoid those types of fees in the past, and, the axiom is no good deed goes unpunished. The allegations about the 2010 interactions is an example of this. If you take a look at Katie Wilkins' affidavit, you will note that she said, we were never asked about increasing the number of units or number of residents at their existing facility on 153rd Lane. The contacts in 2010 were related to the efforts of the Jacksons, or the plans of the Jacksons, to purchase a new facility. And that is the address that's referred to, I guess, on that email. We never had an address. I have attached as exhibits copies of emails related to that, and it's attached to my exhibit 15, I believe. Yeah, about that show the emails that were accepted. 15, they're attached. And I pulled that out, and I have put a rebuttal to all of the allegations about the 2008 and 2010 interactions, because they're not relevant to this inquiry. Anything that we did back in there has been time-barred, long time-barred. And Mr. Jones was advised that this was not a proper subject of the appeal. He admitted, and he acknowledged in his appeal, that the appeal is limited to this decision, but then he brought all this back in. And it really doesn't bear defending, except that it's so inflammatory about what staff did, and it's just wrong. So the contacts that they had in 2010, around June of 2010, was related to a new facility. This email that you were provided is consistent with that. If you will note, it was sent to, purportedly sent, well, it was, I assume, sent to Katie Wilkin at goodyearaz.org. Our address, our email addresses are goodyearaz.gov. They admitted it was not responded to. They never followed up on it. Even had we received it, we would have thought it was referring to the new location, which was consistent with the emails that we did provide you. And I would have to confirm with our IT people, but I don't know our IT people. This document was produced May 8th, Sunday, May 8th, 2011. Our IT people are good, but I don't think they work on Sunday, responding to public records requests. This doesn't look like a document we would have got from a public records request from the city. So, and Katie has stated in her email, and she's looked at her records, she doesn't have this email. And I will tell you this. We have email access to everything that the city receives or sent out since about, I think, when we converted over to our new system. I searched it everywhere for an email of this date and didn't locate it. So this email was never received by the city. And moreover, had it been received, we still wouldn't have, we would have said, it wouldn't have been linked to the current process, or the current property at 153rd Lane. Now, the other thing is, they said, well, the zoning clearances that, the two properties that were, we terminated the zoning clearances for, they wouldn't have had anything to do with this particular property, the new property they were looking at. This is an Estrella Mountain Ranch. The property that they have right now is located in Palm Valley.
Can I just ask a question about that point? The 16645 West Santa Maria Drive address, what is the relationship of that address to the Jacksons? Do you own that property? Okay, just curious. All right, thank you.
The discussions, and Katie can confirm this, but the discussions they had about the new property terminated because the amount of improvements that were going to have to be made to meet the city requirements were just too extensive. This, I think, is probably a two-story property. At least that's what the email suggested, attached to Exhibit 15. And they were talking about an exit off the second story and all kinds of things. And so it just never went anywhere. There was no application filed that was filed. And I would just like to clarify that the city has never refused to accept an application. If they wanted to submit an application and pay money, knowing that an application had already been submitted, they could have. No one would have stopped them. You know, if anything, they can be faulted for trying to, you know, save Mr. Jackson the non-refundable fee. But as I said, no good deed goes unpunished, and perhaps we should change our policy. But the bottom line is, the application that Mr. Jackson submitted was denied, would have been denied had it been accepted on February 22nd, because Mr. Fedson submitted an application that was approved, and his property is located within 1,320 feet. And then, I think it was Joe or Katie just confirmed with their little map quest that the Fedson facility is located within 1,035 feet of Mr. Jackson's facility. So we're asking that you approve the decision rejecting the application. Mr. Jackson's free to pursue a use permit, but the law is clear in this matter. If you're located within another facility that exists, and you know, Mr. Jones conceded once that Fedson application is approved, it exists, then you need a use permit. And we just don't have the authority to disregard the zoning ordinance just because it's only a few houses away. Thank you.
I do have a question for you. I don't know if you can answer it or not. It may not quite be germane to this particular exact subject, but there's one of the exhibits in here from Katie Wilkin talks about when she went out and reviewed the zoning permits for the two facilities that were revoked.
Well, what happened was she reviewed the zoning permits for all, because what happened was, in connection with the census, the staff was asked to confirm all the residency for the assisted living homes in the city. It was part of the census response. And so Katie looked at every zoning clearance that was issued. And so at that point, a number of them were revoked.
So in this particular case, the two that were revoked, if I recall, looking through some of this information that was provided to us, were approved in 2006, I want to say, something like 2006
Yes, and
timeframe.
the problem that we had from a process standpoint is we issued open-ended zoning clearances. We have since changed our process because we discovered that, you know, and generally with commercial operations, you get permission, you move forward with it. And so it's, you know, it's not something that we've seen. But again, you had the downturn in the market, and, you know, I don't think it was, you know, a normal situation. But the city's processes have changed, so now there's a time limit where within which you have to get a certificate of occupancy and start operating, so that we don't have these outstanding zoning clearances as had been in the case. And because they were outstanding and they had no time frame, no automatic expiration date, we actually had to write to the people and make sure, you know, before to notify them and give them the opportunity to.
So what I'm leading up to is I don't know exactly what the zoning ordinance said back then, but under Article 3, Section 3.2.1, Section Bravo, Paragraph 10, Echo, it says the assisted living home shall be subject to annual review and registration with the Community Development Department and annual inspection by the fire department.
Sure.
So it took 4 years to
Yes.
do that review.
Yes. But that doesn't change the fact that we didn't have an application. The last time Mr. Jackson came in and sought to increase the number from his existing facility was in 2011. Now, in 2010, they were looking at a new facility, but there was no application, no discussion of increasing the existing facility. So yes, I recognize that. The city's going to be revisiting all of their ordinances related to assisted living facilities to address some of the issues that we've become aware of, not just here, but you know, the need to differentiate among facilities, which we haven't done in the past. We treat any kind of residential facility as assisted living, and there's degrees of assisted living. So we'll be looking at that in the future also.
And do I understand, like, just for the record, because I didn't see it anywhere in here, other than the fact that they said that he couldn't increase the size of his facility because the other two facilities were within 1,326 feet.
What are you looking at, sir?
Well, I'm looking at the map here.
Oh, this one here?
One of the early exhibits here that we were given talked about the fact that he couldn't get any more than 6 because apparently there was a.
That would have been in 2008.
That was in 2008. And both those other facilities, in fact, were granted for 10 occupants. Okay, I just needed to clarify that. Thank you.
I had one question, and that is, and I'm talking about city ordinance, not policy, something in writing. At the time of application, must that applicant have ownership of the property, and what do you consider ownership?
No. You don't have to, a lot of these applicants are other corporations. So the person who's actually operating it, Successful Journeys, it's Successful Journeys that is licensed by the state. They're kind of the applicant. Because it's a zoning matter, you either want zoning some kind of authorization for the owner or some kind of proprietary interest. But no, it's not necessary to own it. But because it's a zoning matter, we do look to, and mostly that's for the protection of the city, to make sure we're not zoning somebody's property in a way they don't want it zoned.
Okay, and my question is that standard process. So if I ask anyone in zoning, they would say, no, you don't have to own the property to submit applications.
If you have the owner's authorization, you don't have to own the property.
Okay.
Or, yeah. If you don't own the property, you have to have owner's authorization, or if you're purchasing property, we could look to, the contract that's in effect, or, some indicia that it is being sold and that will be completed.
Okay, but there is no ordinance that says.
No.
Okay, thank you.
That was part of one of the questions that I had, and then the second part to that is there a process that city staff undertakes to verify ownership of a property when an application is submitted? I know that oftentimes there's an owner verification letter that's required. I don't believe that was on the checklist of submittal requirements for this particular type of application, so I assume that checkbox is going to be put on there from this point out. But
Yes, it's an issue that we have, not so much with these types of applications, but other zoning applications. I've gone so far as to say, we should figure out if all the owners of the property get a title report because of mostly Prop Up 207. But that's more for the city's protection to make sure that, the owner knows what's going on. But yes, we're looking at those processes too. The attorney for Mr. Fedson is here just to speak on behalf of his client as well, since there's been a challenge to his application and a claim of fraud on the part of his client. This is Jeff Bliley.
Mr. Chairman, can I get an opportunity to rebut, please?
Well, no, everybody's called, and then you can rebut.
Okay.
Thank you, Jeff Bliley, 4800 North Scottsdale Road. It's unfortunate that I have to be here tonight to address this issue regarding fraud on Mr. Fedson's application, and he's had to hire an attorney to do that. The attorney for the other, I can't remember the name of the other assisted living facilities, made a number of accusations regarding fraud, and it's a pretty strong accusation to make. It's a criminal offense. There has to be intent shown there, and I can tell you that Mr. Fedson has not committed any fraud in this matter. Mr. Fedson is not scouring the city of Goodyear making applications for zoning clearance letters on homes he doesn't own in order to secure sites that he can sell later. Mr. Fedson entered into contract to purchase his property on February 1st. He put earnest money down on January 26th. He applied for a zoning clearance letter as part of his due diligence because his intent to purchase this property was open assisted living facility. So before he closed on the property, he wanted to make sure he had the proper zoning clearance in place. This is very standard operating procedure. I can tell you as a zoning attorney, I fill out a number of applications for persons making these type of requests, zoning requests, and I don't own the property. And many, many times in many, many municipalities, they don't ask for authorization from the owner. That comes at a later stage typically. Mr. Jones has pointed out that his client did some kind of an investigation of the site, and on April 1st, because there was a lockbox and a for sale sign still at the site, apparently he didn't own the property. Unfortunately, that's not the test in Arizona for determining when there's a transfer of real property. And in this fact, The deed was executed on the 25th by Mr. Fedson and signed by the bank. This was a foreclosure property, by the way, on the 28th. Under Arizona law, the property changed hands on the 28th. By my recollection of the calendar, February 28th falls well before March 10th, which is when the actual letter was issued. So when the letter was issued by the city for zoning clearance, Mr. Fedson was the legal owner of this property. He closed on the property, paid for the property, and ever since he's received that letter, he's been diligently working towards making the remodels necessary to open the facility. So we're quite offended by the fraud accusation, and just want to make sure we clear that up. Thank you.
Okay, at this time, the applicant has an opportunity for rebuttal.
Yes, Mr. Chairman, just want to address a few things because we've been here a while this evening. With respect to the events that transpired in 2008, 2010, I didn't get into detail about what was going on in the meetings as I conceded. The facts of 2008 and 2010 aren't in question here. What I did want to establish was that as late as 2008 and in 2010, my client had been in constant communication with the city about going to 10. They knew he wanted to go to 10 on his facility, on this facility, specifically when he came in February of this year to inquire about going to 10. He was precluded from going to 10 back in 2010 because of those other properties that were on the record. Through the city's clearing process, they went away. My client wasn't advised that they had gone away because as soon as on the 26th of July, when the city revoked those zoning clearances, he could have walked in and submitted an application for $265 and gone up to it. He had already been in communication with the city just a few weeks before that about going to 10. So the events could have allowed him to do that. So that's addressing 2008, 2010. With respect to Mr. Fedson's application, we're not here to challenge the approval of his application, but reference the fact that, again, the ordinance requires submit, review, and approve to exist. When Mr. Jackson, my client, came to the city on the 26th of February, Mr. Fedson had just submitted his application. The ordinance requires all of these different things to happen before there is an existing assisted living facility. First in time should not mean just because you raced to the counter and submitted an application, you're in and no one else. Fortunately, Mr. Bliley's here. We appreciate him coming and addressing that his client did close on the property and he did act correctly. But the city wasn't aware of that. The city was not inquiring who owned the property or what was going on. Mr. Fedson closed on the property February 28th. The city hadn't asked who owned the property. Their application asked who owned the property. And he signed on there saying that he owned it. There wasn't an owner authorization, anything like that. The city just acted again on March 10th and issued it to him. Yes, he owned the property technically February 28th. He hadn't recorded his deed. We are aware of the statute with respect to when ownership occurs. But we're focusing on the city's process of approving applications. Your only ability as a Board of Adjustment is to address the city's code. The city code requires submit, review, and approve. And then you're an existing facility. In this instance, there was no existing facility on the 16th. In this economy, just like we have these other two properties here that were in existence, they had zoning clearance letters, what if Mr. Fedson had never opened up his facility? He could have gotten his letter and received it and sat on it or whatever, and it never followed through. There's no owner authorization. There's no process. Things can just sit there. Again, it's a constant system of just holding things up. Currently, the city's process, as a result of all this, they have that time, the drop-dead date in the approval. If you don't obtain certificate of occupancies and building permits, your zoning clearance application goes away. That was not the case back in 2008. Was not the case back in 2010. But it was clear, again, through communication with the city, that the Jacksons wanted to go to 10 at their current facility. Again, we appreciate your time this evening. Appreciate Mr. Bliley coming and speaking on behalf of Mr. Fedson's intent with respect to what he submitted to the city. But again, our concerns were when we looked at the property, we did the due diligence on the 31st of April. We contacted the city. The city hadn't even inquired who owned the property, and then the deed was delivered the 4th of April, showing that Mr. Fedson actually did own the property. We're asking for you to look at the city's code, its standard of submit, review, and approve, and exist, and exercise your discretion to grant or reverse the city's denial of of our application based on the totality of the facts of what's going on, all the communication with respect to going to 10, and reverse that and allow us to go. The city's conceded that the distance, I think, based on their calculations, 1,035. I think we had 1,011. We're talking about a few hundred feet separation between the two properties. They're not two right next to each other. They're pretty far apart. If it had been another 200 or 300 feet away, a few more homes, we wouldn't be sitting here this evening. Appreciate your time.
I have one question. Let me see. The current facility at 4434 North 153rd Lane, as that facility currently exists, would it meet does it meet the would it meet the ability to be able to house 10 occupants?
Which property are you referencing?
The specific one in question right
Okay.
now.
Yes, sir.
Okay, that's all I have to ask.
I think you might want to ask staff. I mean, what requirements are you
I-
talking?
That's what I was gonna ask.
I'll get there.
Okay. And then I would have, just add one point that I meant to make. We've never asked Mr. Jackson for his deed or any owner occupancy requirement as well.
Mr. Chairman, I would challenge that. I know my client did provide, not with respect to this zoning clearance, because again, he hasn't gone through this process, but when he went through the permitting and his licensure to open his facility, he did have to provide documentation to the city that he was licensed, that he owned the property. All that had to be provided in order for him to open his facility from day one.
Well,
What
Mr.
he did-
Fesson's
but
going
he
to
didn't-
have to do that too.
But he didn't have to, and he'll have to do that as well. But Mr. Fesson didn't go through, or Mr. Jackson didn't get to go through this process here, didn't have to go through this process, and so there was no requirement to provide it. But through the city's other processes, they did ask him for his ownership documentation when he had to get his license from the state. So the question again is, he's like, why was I asked all this documentation? I had to provide this to the city when I get my license from the state to be able to operate. But in this application, in this process in planning, someone can walk in, submit it, not own it, and go through this process and get issued a letter without the city even asking. So there's this, again, this feel that, why are we not treated the same as everybody else? Thank you.
Mr. Chairman, I have a question that has a couple of parts. Part of it relates to city staff, part of it to the applicant. The reasoning, and this isn't going to be the basis of a decision, but it leads to something else. What is the reasoning for the separation requirement of 1,300 feet of a quarter mile? Is it traffic? Is it business operations? What is the reason for that? Or do you know?
Mr. Chairman, Board Member Keith, the rationale behind it is that when you have facilities that have up to 10 clients, depending on how the facility is operated, it could increase in the amount of vehicle trips to and from the facility, whether there's parking associated with it, and the idea is to prevent an overconcentration in one particular area.
And then it's to avoid materially changing the character of a residential neighborhood, I presume.
That's correct.
And making it, by not making it commercial. So then my follow-up question to that is, has the applicant ever considered submitting for a variance from that as opposed to this avenue that we've taken with this forum?
Mr. Chairman, Board Member Keith, we've looked at that, looking at the variance standards and hardship standards. It was determined that it probably would be a little more difficult to pursue that. We believe that this process, it's the same body coming to you all, you have the ability under the state statute that I provided you to modify in whole or in part. It was a similar process, but the standard, variance standard wasn't included. But it's the same effect.
Thank you.
And then, Mr. Chairman, I'm going to submit, I've got a summary of my presentation outline that I just want to submit for the record as well.
That's fine. Thank you.
May I respond?
Yeah. You responded regarding to,
I want to, just to follow up.
okay, yes.
To the question, I agree with Mr. Jones with respect to the variance answer, but I would point out again that when facilities are less than 1,320 feet apart, the code already provides an administrative remedy by applying for a use permit to demonstrate that an overconcentration wouldn't occur as one of the standards. Thank you.
Thank you.
I do have one question of staff. The facility as it currently exists, when I was looking at the information that was provided to us, it appeared it was a one-story facility, And some of the other, at least the other one, I believe the one that's in question right now is a two-story facility. And I just wanted to inquire whether or not the existing facility as it currently stands would accommodate under city ordinance 10 residents.
I might have misled you, because the existing facility has 6 residents. They're trying to increase it to 10.
Yes.
In February of June of 2010, around June, July 2010, the Jacksons approached staff about a 2-story, and we think that's the one that was in Estrella Mountain Ranch. They didn't talk to the staff about increasing their existing facility at that time. There was no application. The only discussions were about the 2-story facility, and we never had an address, but this email suggests that's the one that they were looking at that time. That was the 2-story. So
Thank you. I understand that. I'm just inquiring about the existing facility.
It's a 1-story.
And what I was inquiring about
sorry.
is, in February this year, he had approached the city about wanting to increase the occupancy of that particular facility.
Yes.
And what I wanted to ascertain was whether or not that particular facility, as it currently stands, would accommodate 10 residents.
Mr. Chairman, I cannot respond to the question as to what the state requirements would be, but it's my understanding that with the city requirements, with the sprinkler system that's already been installed, they would have the ability to go to 10.
Okay, that's what I need to know. Thank you. Okay, is there I believe we had somebody from the president that wanted to speak, or was that the attorney that was here for? Oh, okay, very good. Thank you. If there's no other individuals that care to speak regarding this specific issue, I guess we'll close at this time we'll close the meeting for.
Chairman, may I present? I've prepared some proposed findings of facts
Okay.
and conclusions of law based on the staff's report.
At that time, if there's no other information to be provided, I'd like to close this meeting for a public meeting, and we'll go and discuss this issue and continue our meeting here. Is there anybody here that board members that care to discuss anything?
Mr. Chair, I recommend that we continue on with the meeting and close this portion out and move to G, new business.
Pardon me?
Mr. Chair, the appropriate procedure right now would be for the chair to either call for discussion amongst the members of the board or for a motion to either sustain the appeal, which would be in favor of the applicant, or to deny the appeal. And then you have a roll call vote.
So, although I didn't say that, that's what I was basically trying to say. We're open for discussion between the members. If there's no discussion, we need to entertain a motion to either accept or reject the applicant's position.
And I have a procedural question before we do that. The exhibit that you just handed out, Sarah, can you talk to us about that?
Well, the decision of the board has to be based on findings of fact and conclusions of law. So, based on the city's position, I've prepared the findings of fact that would support the affirmation of the staff's decision and denial of the appeal.
Okay.
Mr. Chairman, if the record could reflect that the applicant just received it as well, so we haven't had a chance to even to rebut or challenge these findings of facts and conclusions of law.
Okay. Mr. Chair, members of the board, the proposed procedure this evening is, should the board decide to take action on this appeal this evening, then the board can do so. Then after that action, whatever it ends up being, then we would have the proposed findings of fact, conclusions of law prepared, either adopting the cities or whatever they may be, which would then be brought back to this body in a subsequent meeting, duly noticed, etc., provided to the applicant, and then those that document would be considered probably a special meeting of this body. And then at that point in time, the proposed findings of fact, conclusions of law would be formally acted upon by the body.
Okay, so that will give us the time to review this, the applicant
Exactly.
to review it. Okay.
Exactly.
Okay.
We set it up that way.
We're just starting to read through the 4 pages and didn't know if we'd be able to get that done before a motion, so.
And that was my
Figured
point.
it
This
out.
is a lot of information to assimilate, to give a fair and honest decision. So I would have that's my point.
Mr. Chair, so the board's options this evening are to, consider a motion. The motion would be either to sustain the appeal, motion would be to either deny the appeal, or if you're not ready to decide, you can table this and carry it over to a special session. Those are the 3 choices. And so the chair should request a motion at this point in time.
So pending any further discussion,
Well, and I guess the thing that's kind of weighing on my mind is the fact that city staff, and I think the applicant would agree with this, the fact that city staff never denied the submittal of an application. I've heard that from city staff. I believe that you agree with that. I know that it was stated in a pre-app session that it was pointless. That word was used a couple times to submit an application, but an application was never attempted to be submitted, nor was it denied the submittal.
Mr. Chairman, Member Keith, the application, after kind of going through all this process and discovering that the property wasn't owned by the individual, on April 1st, in your packet, there was a formal application submitted, which was then denied in May. So that's
2011.
Right, of 2011.
Okay.
Yeah, that's just here. So just, when all this was going on, Mr. Jackson, again, just trying to figure out what's going on, he realized this person didn't own the property, so he submitted his application to the city on April 1st. That was then denied in May. That denial of that application is what's before you.
Okay, but you're still making a point. I'm trying to ask a question for the city earlier. Is there a requirement to own the property? And what the city says at the time is no. So what I'm hearing you saying is that some of your argument is that the property wasn't owned, therefore, blah, blah, blah. And my question to the city was, do you have to own the property to submit the application? And when I heard the city say no.
What I argued was that the application has a line for the property owner when
Okay.
you submit it. Mr. Fedzen signed it as the owner.
Okay.
It didn't say, I'm in the process of owning, I'm in the, anything. And then after April 1st, or between April 1st and April 4th, is when the city received the copy of the deed and then
Okay.
gave us a copy. But by then, they'd already approved it.
so if we're not prepared to, if we're not going to discuss this anymore or not going to make a motion, we either need to make a motion to accept or deny the applicant's position or table this for a future meeting.
Mr. Chair, it's correct. You have the 3 choices: a motion to sustain the appeal, a motion to deny the appeal, or a motion to table it to your next meeting.
Mr. Chair, I make a motion to table this to our next meeting.
I have a motion to table it to a future meeting. Do I have a second? Well, I don't have a second, then I guess we can't vote on the motion.
That's one.
So,
And I'll speak to that. We were given, the packet had a lot of information for one particular case, but I think we were given enough time to review this, and we've basically heard testimony to that effect from both sides and additional information for us to review. So I think we have enough information to act on this case, unless there's really more time that you need to review the case, or are there additional questions that we want to ask of the staff or the applicant to come back and present to us? What are you thinking there?
As a small business owner, a lot of these things are very familiar with me.
Sure.
In terms of submitting an application, it's not going to happen this year, and those comments can be taken as, you know, my opinion. You can interpret those as to, hey, I'm trying to save you money, or but the process. And I am a process-driven person, and I'm a person who follows the law as a small business owner. You know, there's a lot of information here that has been characterized as tough words like fraud, which are tough words to use in my opinion. There are emails with wrong email addresses, but the assumption that the city received the email, and that's why, you know, there's a lot of characterization of, I won't say misdoing, but ill intent. And with that being said, trying to sift through that and get to the truth is the nature of my being here tonight as a board member. Again, I think that with discussion among the board, I think we can probably give a fair and honest, at least I can, at the next meeting. And I'm also willing to say that meeting should have a timetable. I'm not talking next month or 4 weeks from now. But I think in order to give a fair and just and opinion, that I would like to just go over the facts again. It's a lot. I got the facts. I read through a lot, but we've also received a lot of information here tonight, which is the first time I've got a chance to see this. Sure. And I think on behalf of the city, they presented their case, and the applicant has presented their case. But to make sure that we move forward in the best interest of the city and the taxpayers, my point would be to table this for another meeting at a soon-to-be determined date.
So the motion has been made. There's been no second. If we're not going to second it, we need to
I'll
either
second
make a
it.
motion to either to deny or sustain the motion from the applicant, or the application from the applicant.
Based on that reasoning, I'll second the motion to continue if it's for the purpose of reviewing the additional information that has come before us tonight, and with a time certainty associated with scheduling that next meeting in the near future.
It's been moved and seconded to table this agenda item to a future meeting, so we can have additional time to review the information presented. All those in favor signify by saying aye.
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 I have a nay also.
I have a nay. So what do we do in a case like
The motion dies.
Fails.
You need a new motion.
Okay. So then the motion is to deny the applicant's,
Uphold the decision.
whole decision then, I guess.
It's either, we either have to table the motion, or we have to, or table the item for a later meeting, or make a motion to support the applicant or deny the applicant's request.
Okay. Mr. Chair, you already had the motion to table, which failed. That leaves a motion to either sustain the appeal or a motion to deny the appeal.
How about a motion to deny the appeal then?
Okay, I'll second that.
We have a motion to deny the appeal. It's been seconded. All those in favor signify by saying aye.
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 Nay.
Nay.
Nay. 3-1, you win. You have
What was your vote?
It was two ayes and 2 nays.
And that's, okay. And that motion also fails. No,
Yeah.
motion was to deny the appeal. Is that correct?
So it appears to me we're at a standstill.
Well, can I interject a few things into this discussion at this
Okay.
time?
excuse me?
May I interject a few things in the discussion for maybe another decision on this? As my colleague down here on the board had mentioned, he's a small businessman. I am as well. We find that sometimes working with municipalities is not the easiest duties to do in business. But as a small businessman and an international salesman, getting told something is pointless, not taking time to follow up, not following up on emails. Mr. Jackson had 8 months to revert back to the city, contact them, drive down here, talk to them, ask them why you haven't responded to my emails, called them, followed up on it, and be a little more aggressive if this is what he was wanting to do so intently. There's an 8-month interim in this time span that he had the opportunity to pursue this to the fullest of his extent. Mr. Jones here used the analogy, you're trying to pick up girls and they say it's pointless. Are you married, Mr. Jones? Because
17 years.
I've been married 36 years. So I'll just tell you, if I kept hearing no from her, I wouldn't have been married. But the whole thing is, you don't give up. And you don't give up when you're in business. If you do, you will not make it. Or you miss a fine window of opportunity that Mr. Jackson did. It was unfortunate what had it occurred. There was somebody that made that window before he did, just by days. And it's a small thing. But by the city laws and ordinances, that's what we're judging by. We're not here to change the laws or change the ordinances. That's for the city to do and Mr. Jackson to work out later on with his attorney to get a variance through the city by changing something of this nature. But the facts that are presented here show that Mr. Jackson just missed that fine window of opportunity. He had several months in between there to follow up on it as a business person, to be aggressively enough to go after it. I don't listen to anybody waiting back for something. If I'm wanting to make a sale or a deal or improvement in my business, I don't sit still until I get a final definite answer instantly on my emails, phone calls, or everything else. And unfortunately, there was a time span there that just set in lull, and it exceeded by him. And it's sorry that he had spent the money to get a lawyer and go through all this troubles, but I don't think we need to review this any further than what we have. So I would like to put a motion back out there to say I would like to deny the applicant's appeal on this, because I think if he was more aggressive, he would have got his in there as soon as the city found out the others were closed up and nobody else was around. If he was staying on it, I know with the help of the city and the other people within the staff of the city, they would have helped him and guided him and had his permit to increase in a due amount of time.
I understand it wasn't the city's intent to try to throw roadblocks.
No, they weren't. They were just following the procedures. But he can come to the city and push him to help him get to where he was. They're not here to deny anything. They're here to help you. And if you just progressively stay on them, you'll eventually get what you want. And unfortunately, the window has closed, and it's beyond that, and somebody else beat him to a facility that's within a designated amount of area, of footage apart, and that's sad. But I feel for him. I know where he's coming from, because as a businessman myself, I've been in those places as well. But it's just he missed the window. That's all there is to it.
So did I hear you make another motion?
I made another motion.
Do I have a
Now,
second?
I hope my interjection of this, I'm a little nervous at this point because I'm on video. But I think, we've seen the facts, and I don't perceive there was any fraudulent or mis-city communications in all of this. It was just an unfortunate fact, that he didn't pursue it hard enough during that 8-month time span, and when he first started contemplating and asking about it.
And just for clarification, the motion is to uphold staff's appeal.
That is correct.
I'm sorry.
It's to deny the applicant
Right.
the appeal of the staff decision.
Mr. Chair, I have one procedural clarification for you. Should the present motion to deny fail, that does not mean that the applicant's appeal is sustained. They have to have 3 votes of this body to have their appeal sustained. So if you cannot reach a decision, then the appeal effectively would be denied unless they get the 3 votes. Do you understand?
I understand.
Okay, thank you.
So it's been moved. Do I have a second?
Second.
It's been moved and seconded. All those in favor?
What was the motion? I didn't hear the motion. What was
To
the motion?
uphold staff's decision.
To deny the appeal.
To deny the staff's decision.
Wasn't that already voted on? The motion to deny had already been voted on.
And that's where I'm confused from a procedural standpoint. We've already had
The
that.
only other motion on the table I thought was to sustain our appeal. That was the third option.
We still made it on.
They can bring back the motion to deny or deny if they want to, or else sustain the staff.
We've had further discussion, so
You're bringing back the failed motion?
Yes.
all those in favor signify by saying aye.
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 Nay. You have 3.
Motion is passed. Okay. We don't, do we have, I don't believe we have any more new business on the agenda. Resolutions? No, since there's no business, no resolutions, this meeting's adjourned.